good afternoon if you are on the East Coast in the United States, and good morning if you're on the West Coast, and probably good night if you are in another country overseas. I am Kaylin Romaine, the founder and CEO of the Forward Collective Group. This is part four of a four-part series that I've been hosting since the end of last year. I can't believe it's like, I'm going to say a year ago just to be cheeky, but on IP protection. This has been such an integral part of my business development strategy and my business transformation strategy. And when I talk to my small business peers, I've heard so much fear, anxiety, a little bit of hesitation. And I want to make sure that y'all have what you need to succeed. So, as you know, in the first three webinars, you had a chance to meet some incredible people, most of whom are on this call today. But as well, we got a chance to hear directly from the US Patent and Trademark Office. So, that was a real treat. And the opportunity to hear directly from USPTO was special because we got to learn about all the resources that are available on their website, all of the resources that are available live and in person through their resource centers, which happen at libraries across the country. And we got a chance to see and hear from the experts, again, most of whom you've heard from before in the other webinars, about how to protect your IP globally, locally, how you can use the resources that the USPTO has, and the role of legal support and partnership in the process. We covered a lot. So if you are like, girl, I didn't see all of that, no worries. Go back and check on LinkedIn and the YouTube channel, Fast Forward Podcast, to see the old webinars. They are all up completely there, as well as contact information. This session, once it's concluded, it will also be posted on YouTube and LinkedIn, so you still have a chance for it to live someplace. But I wanted to have an open Q&A session with trademark attorneys because I know that through the three sessions we had, again, it probably was a ton of information. It felt like you were drinking from a fire hose. And you needed to go back and kind of process and think through everything that you were hearing. So I'm excited for you to get the chance to ask questions today. The chat is live, so you can feel free to drop your questions in the chat. I've also gotten feedback from people after each of the sessions. And so I've compiled a list of questions here. So if you see me looking off to the side, I got my list ready to ask these amazing experts. But again, you can use the chat and then also be sure to comment in the future because I'm sure they'll be checking back and I'll try to forward questions or answer them where I can. All right, so let's get started for today. I want to start by giving these amazing attorneys a chance to introduce themselves because I want you to hear directly from them about their experience, their expertise, and honestly, what they enjoy and value the most about their work. So I'm going to call out the order because we got a bunch of people today. And so I would like to hear from, let's see, who's going to be my first victim. Da, 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 da. Okay, let's start with Joanna. Then I'll go to Judy, then Sabrina, and then we'll close it out with Steve. I think Xavier dropped, his internet might have dropped. Because, by the way, y'all, if you're in these storms or if you're in LA with the fires, please take care of yourself. It is very crazy right now. It's another reason why I'm glad the replay is going to be live. So please be safe, be warm, and I hope that you and your family are finding peace and comfort in these very crazy times. So, just real quick to review the order again, we're going to start with Joanna, then we'll go to Judy, then Sabrina, and then Steve. And hopefully by that time, Xavier will be back and I'll add him back to the call. Joanna?
Hi. Well, Kaylin, thank you and good morning. Thank you for having us. Um, my name is Joanna Luna. I am an attorney at Omnis Law. I work with two practice groups. One is with IP, doing trademark work. The other is with the AI tech transactions and cybersecurity practice group. And I focus a lot of my practice on international IP protection, which is a little bit different. And I also teach on the side, and I'm an adjunct professor for the Stevens Institute of Technology, where we start information security and the law next week. So pretty excited about that.
Congrats on that. All right,
Thank you.
Judy.
Yeah, hi everyone. My name is Judy Yan. I am a California attorney located in Los Angeles, California. As you can see, it's not too bad right now where I am, so very lucky. Um, I am initially from Taipei, Taiwan. I moved to Los Angeles, California a while back and I've settled in here Since I became a lawyer, I've been helping small businesses in Los Angeles and creators around the world with their intellectual property. So very excited to be here to share something I know with everyone.
Thank you so much. All right, Sabrina.
Hi, Kaylin. Thanks again for having us. My name is Sabrina Cobb. I'm Associate Corporate Counsel at a global technology company, GBG PLC, where we specialize in identity verification and fraud solutions. I specialize in contract negotiations and technology transactions, IP protection, primarily through trademarks and contracts, as well as managing pre-litigation and litigation matters as well. I'm an attorney here in Georgia, so I am in the midst of snow right now. So we'll see how that goes. But yeah, thanks again for having me.
And sorry, Steve, before you hop in real quick, I got to tell y'all. So, Sabrina is the attorney who has handled most of my trademarks. I love her dearly, and I'm so appreciative that she could join this session today. So happy about that. Again, I have a little bit
Yes.
of a favoritism issue, but this is like the love of my life, low key,
We've
because she
been
has helped
together
me
for
get
a long time.
she helped me get my IP games together. So I have a special connection with Sabrina, y'all. Okay, Steven, go ahead.
Thank you, Kaylin. Sabrina, very nice to meet you and my colleagues are on with us today. Very happy to be here, and thank you for having us on this wonderful opportunity. My practice has been primarily in intellectual property. I've been doing it for quite some time. I've been at many firms throughout my career, primarily helping entrepreneurs, small and medium businesses, and even some large businesses with their intellectual property portfolios. Including certainly a significant amount of trademark work for things in the areas of computer science, computer hardware, software, as well as in consumer product goods. So happy to be here to share. And I'm in Chicago today, and it's very cold, a little bit of snow, but certainly not as bad as some of the other areas. And we certainly hope everyone is doing well, particularly in California.
Thank you so much. Xavier, I'm so happy you made it back just in time. Can you introduce yourself and share with us your expertise and what you value most about your work?
Intellectual property attorney. I practice in the areas of patent, trademarks, and copyrights. I've done a lot of trademark work, patent work, and a little bit of copyright work. So I work with entrepreneurs and business owners to protect their IP. So I worked on blockchain technology, patent application on blockchain technology, artificial intelligence, and so forth. Work with people that's in the tech space or in the trademarks, fashion space, and so forth. So pretty much what the clients need. So what I value about my work is to be able to help clients to achieve their goals.
Thank you so much. I appreciate that background. It's interesting because so much of what we think of as copyrightable, and I know that that's probably not a word, but patentable, trademarkable is usually technology. But what I've learned from all of you in the sessions and just in my work with y'all is that any idea that you have, it deserves to be protected. And so I know I've said this a bunch in these webinars. People probably tired of hearing it, but it's so important. Your creativity deserves protection. Your ideas deserve protection. If you start a company, guess what? You're a founder. If you create something, guess what? You're an inventor, you're a creator. And so I think we give these labels to people who we think are the type of people who should be creators or inventors or founders, but really all of us have that capacity. And so I hope that that's one of the biggest take home messages that you get from not only me, but from these experts. So let's go to our first question. One of the things that has come up for people is the idea of how do I know that I'm able to trademark something, right? That it's defensible. So the first question is, how can I tell if my trademark is strong enough to be defensible? I'm going to start again because I got a little bit of a bias. I'm going to start with Sabrina because she and I had this question about a couple of the things that I've trademarked. And so we're going to go from Sabrina to Steve and then Joanna. And if Judy and Xavier want to hop in on this question, please feel free. Sabrina?
I think the biggest thing in making sure you have like a strong enough trademark that is defensible is picking a strong mark initially. So making sure you're picking something that's distinctive, whether it be fanciful, arbitrary, or suggestive. Stay away from anything that has too many descriptive terms, anything that makes your mark super weak. Be more creative, the more made up, the better. I think that is the first thing, because I come across a lot of people who fall in love with names. And they are the most descriptive names out there. And it's about reminding clients, right, that this is supposed to be a source identifier. So you want to be findable, right? Having all the descriptive terms are not going to make you findable on Google or any other search engine. So it's important to make sure that the name that you're picking is super unique. And once you start there and take the process of protecting everything, that gives you a really solid foundation.
Thank you, Steve.
Yes, sure. So picking up where Sabrina started with us. So, I mean, clearly choosing a mark that where you are in the marketplace and you can avoid confusion with others, right? So that's really important. You have to assess the similarities of marks that are in the marketplace. Certainly a search is really important in starting the opportunity to identify what your brand is, what it should be, and how you can build it. And then, of course, with that, you want to be sure that you're doing adequate research and due diligence. You don't want to overlook, let's say, existing trademarks, so that you can be sure that you're going to end up with a niche that is going to be protectable for you overall.
Thank you. And Joanna?
Okay, now you can hear me. So to Steve's point, absolutely, the search is critical, and it's. I think that it's something that, depending on a business owner's experience and sophistication, sometimes that's a step that's often missed. And so I think actually it's a combination of Sabrina's suggestion, which is, you want to have a term that's fanciful, that's arbitrary, something that's unique. And at the same time, it's something that when a search is run for that particular term, that it's something that's not likely to be confused in the marketplace. Something that we tend to see quite a bit is, clients come and see us because, at least, for me personally, they come when they get a piece of paper called an office action with two little things, which are the number 2 and the letter D. And that means that the examiner has determined that there is someone else's mark out there that's either already registered or it already exists. And so because your term is too close, then you begin the walk up a very steep hill to get your registration. So the search is foundational.
Absolutely. And I want to hop in with my perspective on this one, because I think that's something that I struggle to understand. And this is also why we told y'all legal partnership helps a lot. Because when I get back the search result and it's pages and pages and pages of, hey, this seems close, this might be similar, this might end up as an office action, I'm glad it wasn't me who just jumped out there, because this stuff costs money and it takes time. So please do your due diligence in both the creativity and the process. Judy, you wanted to hop in and share something?
Yeah, it's actually building on what everyone has already mentioned, but there's this thing that I've encountered a few times, and I think people often not know about it. It's that a lot of businesses want to trademark using their last name, and last names are shared by a lot of people. So sometimes when that's the name you want to use, you will get an office action. And then there are ways to trademark names with your last name, but it's like a more complicated process. Just something to remind everyone. I think it's important because it's come up for me a few times.
Sorry, I'm a serial muter, y'all. So I'm like, get off the mute button fast. So it's interesting that you say that, Judy, because a lot of folks, when they start a company, especially if it's something like NAICS code 541611, which is general management consulting, any legal purpose, which I understand because when you first start a business, you need to be dynamic. But when we start a business, we'll want to call it our last name consulting. And so when I'm coaching clients, I always tell folks, no, come up with a name. First of all, because to your point, Johnson Consulting Inc. or Johnson Consulting LLC, I'm pretty sure there are like a million of those across the United States alone. So that's not unique. And you probably won't be able to trademark that name. You maybe could trademark the logo, perhaps. But again, sometimes we do like that quick little design in Canva or some other software, and it looks just like everybody else's stuff. But the other reason why I advise against that, and this is speaking to Sabrina's point about creativity, even with your company name, is because the company will likely grow beyond just you. So I'll use my company as an example. When it was called Dream Forward Consultant and I started the company, it was literally just me. And in my mind, I had no intention to really have a staff at any point per se. And then eventually I brought on some people and I was glad. I'm like, oh, I'm so glad this isn't called, Kalen Consulting Inc. because it's bigger than me now. And these people, I don't end up on every client call. They're representing the company themselves. And so I was glad that it had a real name. But even with, well, I don't say a real name, but a name that wasn't my name. But even at that point, as I began to change verticals and add new services, I realized that even Dream Forward Consulting was limiting because there were certain things I was adding on, and people had gotten so used to that name. They were like, no, you don't do that. We didn't know you did that. And so, ironically, when Sabrina and I were working on trademarks for all of my company names, we wanted to trademark Dream Forward Consulting. And in her search, she was like, I don't think it's strong enough. I think it's pretty weak, and you probably would get office actions on it. We potentially could do the logo. And I was like, let's wait because I was thinking about refreshing the logo. And now I'm glad that I waited because I have a totally different name now. And honestly, I think that one might be strong enough to go for the trademark. I'll see. So I'm gonna be in touch about that eventually. But again, your company evolves, your business ventures evolve. And so while yes, you do want to go for that early protection, we talked about that in one of the previous webinars, how important it is to protect your intellectual property early in your journey. A part of that early journey should also be that uniqueness, that creativity, that distinction, and the differentiator in everything from your name to your logo to your slogan, right? All of the things that make your company your company. So please don't be afraid to be creative because, from what the experts just shared, that's actually the thing that will make your intellectual property more protectable. I'm making up words all day today, and it sounds like they all end in able. So, if you want your stuff to be more protectable, it sounds like you need to turn on that creative genius. All right, next question. Let's see. Are there any recent changes or updates to trademark law that businesses should be aware of? Now, this is interesting. I actually want to rotate to Judy, Xavier, and Joanna for this one because I know you all talked in previous sessions a lot about global intellectual property protection. And so I'd like to hear, um, again, just what changes may be happening. How should people be preparing? How should people who are maybe already in the process be thinking about it in case they get office actions, just so we can prepare? So again, Judy, Xavier, and then Joanna, and of course, if Sabrina and Steve want to hop in, you can.
Hi, so off the top of my head, something just happened recently is that the USPTO has an overall increase in all the filing fees. So that's something that everyone should be aware of. Now it's too late, but if you could file something, I would say try to do it early because the fees do increase from time to time. Like when the filing window opens and you can file, you should do it. Um, and another trend I have observed from my work is that I would say the USPTO has gotten stricter and stricter with descriptiveness in trademarks. So it is the tendency of most marketing people or people who are in charge of branding that they want the mark to describe what they do, describe the brand value, describe the goods they sell. And sometimes, unfortunately, with trademark law, that actually becomes a problem. So those are the two trends I will share about this.
Office action dealing with likelihood of confusion. So the examiner attorneys are becoming more broader in what they consider to be likelihood of confusion. That's what I'm starting to recognize. For example, everybody on the panel will realize that if you have the same word, if both marks starts with the same word, and the remaining part of the word may be disclaim or descriptive, they're going to issue a likelihood of confusion as long as the goods and services are similar. And it's becoming very difficult to overcome that now. That's what I'm starting to realize is a trend. But in addition to that, I also echo what Judy just said, that the fees have increased. And so you have to be on the watch out about fees increasing because it does take a long time. So if you're in the process of thinking about what you're going to do, make sure you get it filed as soon as possible.
Joanna?
Yes. So yes, to Xavier's point, I actually had something similar happen to me not that long ago, in that I got an office action where my client's mark had contained, it was a composite mark, meaning that it had a few terms and they were all together. But I had two marks that were cited. One of them where I was able to overcome the refusal because of the dominant portion of one mark versus the other was different, to where, that I was able to make it work on the first cited mark. However, for the second, I wasn't able to. And yeah, I wasn't able to. And so it's when you're encountering these 2D refusals, it's in a way you have to go into it with eyes wide open, that because the examiners are getting broader in how they argue, you kind of have to go into the process understanding, like, okay, like, this is, the attorney's going to do the best job that they can, but at least the way that the examiners are working right now, it's a 50-50 shot at this point. And that's in part because the examiners are not really bound to follow what another examiner has done. And so you can say, well, this cited mark was approved under these circumstances, which are quite similar to mine. And so mine should be able to go through. And what the examiner says, and they'll tell it in writing, they'll say, I don't have to follow what the other examiner did. So yeah, you have to keep an eye out for that.
So wait, okay, because I got a comment about that, because I'm like, whoop, whoop. First of all, this is why I hope, now y'all know we've been doing these sessions since December. So I hope that you were taking action then, because I'm pretty sure some of these things went into effect probably January 1st or at some point this month. So, time is of the essence. Make sure you get on it to at least start the process. But note, it's not like case law, and I'm making this up because y'all know I'm not an attorney, but it's not like case law where if there's a precedent for something, 9 times out of 10, you're going to follow everything that comes after that. The subsequent case is going to be that. This is by examiner. Now, let me also make sure I get this clarification. One, because I know the USPTO going to be like, no, man. It is not to say every examiner is just out here doing stuff willy-nilly. They have policies, guidelines, best practices, right? They work in teams. They work for the agency, which is the USPTO. So this is not like the wild, wild west of trademarks, patents, and copyrights. However, the point that the attorneys on this panel are sharing is that there is discretion which can be used by examiner, particularly when there is a lot of similarity between what you are submitting and what someone else is submitting. The hard part with that is you don't know what other people have submitted until it goes public, meaning that it has been fully registered, filed, all of that good stuff. So if somebody else's trademark, patent, copyright is in the process, you don't know what could be similar or what's not. And that is another reason why I strongly suggest please get legal partners, because to the point in our last webinar when Tara was talking about how she felt when she got the office actions, and it was like, what the heck, y'all are, trying to block my baby. We have a personal attachment to our businesses, to our creative inventions, etc. And so sometimes we can't think logically and in a grounded way to respond back to this, to know how to work it around. So if it's 50-50 with an attorney, 9 times out of 10 with you working by yourself, it's going to be like 10-90, with the 90 falling on. We might not get to push this through because you don't necessarily know all of the specifics to being able to use the right descriptors to respond appropriately to office actions. Not because you're not smart, but because we're not attorneys. We have other areas of expertise. So please, that legal partnership is super important. We've talked about the resources that are available for free on the USPTO's website and through the USPTO's resource centers. So if you want to do your due diligence and get prepared before you go and find legal partnership, that's cool. But I would never suggest to anyone to go at the process alone and just assume you could do it, just because as somebody who now, what, Sabrina, I think I have like 13 trademarks out there. Like, it is not an easy process, especially if you have more than one, and especially if you have more than 5. It's a lot to manage, and that probably is not your expertise. All right, enough of my soapbox about that. Let's see. A good question. This is a good one, especially for international businesses, because I know a lot of people are expanding their businesses global. This year, I've gotten so much feedback and questions from my peers who are expanding like me. So, for international businesses, whether that is a US based business who is now opening, let's say, a hub in another country, or a business in another country that perhaps is now starting to do business in the United States, what are the key considerations for trademark protection in different countries? For this one, I actually want to start with Steve, and then I want to go to Judy and then Joanna, because I know in the previous webinars you all have talked specifically about work you've done, particularly with the international side of it. So, Steve, let's start us off.
Great. Thank you. So some of the key considerations for international trademark protection, identifying your target markets. You need to start out with understanding where you're going to be selling your goods and offering your services. And with that, then you can hopefully kind of map out the world and decide where you might want to go. And again, getting back to trademark searches, comprehensive trademark searches are so important, particularly in international protection areas, because there are, so many uses of different terms in different languages even that cause all sorts of potential conflicts worldwide. So if you really want to be in these countries, you really need to do a very comprehensive search. It can be expensive sometimes, but it's well worth the money spent up front. And certainly utilizing the international treaties is really important. Madrid Protocol, Paris Convention, all of these unique opportunities to be able to put yourself in a position to protect your brands worldwide. So with that, I'll turn it over to whoever's next.
Actually, Steve, can I ask you a quick follow-up with that, Judy, before you hop in? Because you mentioned about the language differences, and especially with the boom in social media content creation, and people are now able to trademark things like dances, slang, etc. That language difference can be a significant barrier. Have you had any cases, or what are some of the trends that you've seen, particularly around the use of slang and how that could impact barriers with the international trademarking, just because there's a translation, maybe sometimes confusion?
Sure. So yes, certainly the ability to get a translator involved early on when you see foreign marks come back in searches is so important. Typically, you won't have that opportunity to be able to leverage that with your attorney because they likely don't speak multiple languages. But if you need to get a translator involved, I think that's probably the key factor early on to be able to identify if there are potential issues. On the slang portion of things, sometimes those are a little bit more difficult to get registered particularly in foreign countries, because they have specific meanings. Potentially they've already come into commerce in some way in advance, and so with that, I've seen some instances where examiners and offices will take positions that may not be really pro applicant in those opportunities.
Thank you so much,
Sure.
Judy.
Yeah. So an important thing is depending on what you're selling, what service you're providing, in certain jurisdictions that may not be an allowed category because of the cultural differences and legal differences. For example, I was helping with the tequila brand with their trademark, and in UAE, there's actually no class 33 for liquor because the religion or legal system there doesn't allow that. So that's something to consider depending on where you think you will take your business to. Another thing is that I think I might have mentioned it before in other webinar series is that different country, different jurisdictions have different trademark system. In the US, you want to use your mark as early as possible. In certain places, you want to register as early as possible. And along with kind of the translation issue, for example, in China, that's a country where you want to register as early as possible. Um, there are several different ways to translate, for example, an English name into Chinese. And there are a lot of trademark squatters that will just register translated names of multiple versions of translated names of a famous brand. They're just waiting for you to expand there, and you finally are ready to do it. And their application or registration could block yours. So if, for example, if you or me, like you have an Asian background, you grew up there, you think you're more very likely take your business there at some point, you should try to act fast and make sure the name you select is clear there. You should register as soon as you're ready.
Thank you so much, Joanna.
Yes, this is layering on what my colleagues have said. Here's on the more nitty-gritty side of things, which is, every country has its rules and its examination procedure, but what most places require, and this is something to count into your budget before you're filing, is costs of translation, costs of legalization of documents, and make sure you apostille your documents. Because when you're filing internationally, for the receiving office to accept your paperwork, right? Your paperwork needs to be in the local language. Powers of attorney, anything with a signature needs to be authenticated so that the receiving office can accept it. So those are some additional costs, but on the boots on the ground level that certainly business need to keep in mind, because it's not going to be just the filing fee or maybe just the attorney fee, but you're going to have those additional costs involved as well. So make sure that you budget and you plan for those, and do your due diligence, get your recommendations on solid local counsel, because they are going to be the ones that accompany you through the process. And so they're going to tell you exactly what it is that you need and in what order. And those are my 2 cents.
I have a follow-up question for you, Joanna, and then
Mhm.
I have a comment on what Judy shared. So the follow-up question, because what you just said, I want to first clarify that. I think sometimes in the US, we are very used to being the center of power, whether that's politically or socially, right? The purveyor of culture, right? The holder of culture. This is not that, right? Countries have the right to have jurisdiction over the processes, the legalities, what they can allow. And so some of this is even the mental readiness and preparation to recognize that you are required to have some cultural humility in order to trademark and protect copyright, patent, right, even as far as trade secrets, to protect your intellectual property internationally. So before you even contact an attorney, especially in another country, check yourself to say, okay, I think this is important. This could probably fly in my country, but I need to be prepared and give myself the time, the money allocated, and the energy and patience allocated to see this process through, no matter the outcome. Because as you were saying, Joanna, it's
Mhm.
possible that what is flying in this country, whether it's language, sometimes not knowing like legal customs. Y'all know every industry has its own unspoken rules, cultural trends, right? And so in law, there are things that we definitely don't know about attorneys here in the States, and we certainly aren't going to know for every country in the world. So, again, that patience, the right resources as far as money, and allocating that time, that's going to be very important. So, I said all that to say, Joanna, here's the question for you. How can us as founders, creators, and inventors boost our cultural humility to be ready to see this process through, especially when we're coming from an American lens?
I would say if budget permits, if time permits, I think that going to spend time in the country where you're looking to do business, and I'm not saying, go and spend 6 months, but I would say go and spend a good couple of weeks to see what it's like to interact with people there, to go look for information. If there's, if there's an attorney or a friend, that you have that lives there that can kind of hold your hand while you're going to the offices to get information, I think that goes a lot. I think that definitely can help to get that cultural humility. Yes, as a country, we're sophisticated, but there's jurisdictions outside the US where I would even say they're probably even more sophisticated than we are. And they have solid processes. There are some countries whose IP law is actually modeled on our own. And so when you have a country like Chile is one of those places. If you're trying to protect something over there, that culture shock that you might experience with the legal system, it's not as much because their law is modeled on our own. But that being said, one of the things that is really important to remember when you're working internationally is that in most civil law jurisdictions, you have to meet two big requirements with the application. And this applies to patents as well, which is the examiners are looking for form and they're looking for substance. And so what does that mean? Form, that means that the applications need to be drafted a certain way. Or in the case of patents, the claims have to be structured a certain way. And that's how it has to be written to comply with local requirements. And that's why having local counsel is incredibly useful, so that when you submit that application, whether it's for a trademark or for something else, you're doing it right the first time.
Thank you so much for that clarification. I have a comment on what Judy shared because this was super important. There are people, of course, people are going to know more about the written and unwritten rules of the game in their country. You do not live there, right? And so I need you all to be aware of the fact, poachers, pirates, these folks who wait to grab things is not just in one country. They do that here. I think I mentioned that about the domain name. So, and I just told a business client this like a week ago because we were workshopping the name that this person could use for a new coaching program that they're creating. And I was like, go get the domains right now. I checked for them and was like, I see that they're available. Go get them right now. They on like $11. Because as soon as you file those applications and this is in the States, it's public. Like it goes out there as soon as you file. So somebody's gonna start grabbing domains and then they're gonna hold it hostage, try to charge you 5K and up. Like 5K is table stakes. That's the lowest. If it's something that they think you really want, oh, we could get up to even six figures. So you cannot play those types of games. But now, as you see, like Judy said, it's even your name, right? It's even other names that folks know are common. Again, I know at best I might be a little proficient in maybe 3 languages. I'm not fluent and a native speaker in every language in the world. Period. I don't think anybody is. I got to check the Guinness Book of World Records to see. But the point is, you can't know all of that. So having the right partners, sequencing your steps is so important because you cannot make things happen without having that sequence together. Or if you can make it happen, it's going to be much more arduous. And that gets back to that time, resourcing, and energy. It's just not worth it. So please, please, please keep in mind these very important considerations that were shared by our panelists. All right, here we go. Next question. We getting down to the wire now. So, can you explain the difference between the symbols? So that R with the circle, the superscript TM, and the SM symbols, and when each should be used. So for this one, I'm going to start with Xavier, then I'm going to go to Sabrina, and then I'll end with Steve for this question.
You can only use that when you have a registered trademark, and that's based off the territory which you got the registered trademark in. Now, the TM and the SM that you see, those are common law marks. So those are unregistered marks. So you can use them anytime on your products and services. Specifically, TM stands for as a product, SM service mark. So just FYI. So just to recap, our registered mark is only for registered trademarks. TM and SM is for unregistered marks.
So real quick, just to differentiate that, so you use the R once you go through the whole process and officially get your certificate from USPTO or the governing agency. TM and SM can be used at any time, but in particular, if you are in the process, correct?
Yes, that is correct.
Perfect. All right, here we go. Sabrina.
I don't really have much to add. Kind of what Xavier said is kind of just the blanket rule. But I will add this, that once you have a federally registered trademark and you have that R symbol, you need to be using it in your mark to be able to, take advantages of some of the things that come with being federally registered. So being able to have jurisdiction in federal court, being able to maybe have statutory damages as a possible thing you can collect, things of that nature. It's the point of these symbols is to provide constructive notice to other people who are doing business that these marks are being used for certain business purposes. And the R specifically is to show and give that notice that this is a federally registered trademark. So it just is important to make sure that you are using it, because if you're not using the R specifically, you can lose some of the protections from it.
Thank you. And now I got to go update my website because you're absolutely right, girl. I just thought about it. I'm like, hold on, I'm slipping. Okay, sorry. Go ahead, Josh.
So yeah, to continue with where Sabrina was going here, certainly the enforcement aspect of opportunities are significantly important, and marking, which is what this is called, is really important, both for the common law, the SM and the TM identifications, for purposes of being able to provide evidence if there is any potential conflict down the road that you were the earliest user or adopter of that mark. It's all about dates. It's all about dates of first use, and common law counts. So you need to be cognizant of that. And then, of course, the damages aspect, you want to be sure that you're marking and getting that public interface out there so that they know that you are protecting your marks. And then certainly you also have to continue to monitor and enforce your marks in order while you're marking, in order to be able to claim damages and continue with the validity of your marks so they don't become commonplace, right? That's the important part of all this.
Again, now y'all got me a little shook. So my task for this week is to go do an audit of all my websites, all of my good stuff, to make sure that I'm using things appropriately. One in particular comes to mind, and I'm like, I know for a fact I need to go make sure to add that symbol. And thank you for that. The last thing I'll say, and this is as a person with trademarks, you put in all that work. You paid that money, like you did all that. You waited all that time. You might have had to respond to all these Alphas actions and work with your legal counsel. Show it off. It is worth showing off. I know that adds a lot of credibility to my business right? And not just for things like company names or even logos and things like that, but especially for phrases. So I have a couple phrases that I've trademarked. Sabrina, keep me honest. One of them is evolution to equity, and another is emerging and
Emerging,
evolving entrepreneurs.
yeah.
That's the other one. Yes. Thank you. See, so that one, emerging and evolving entrepreneurs in particular, I have in my business strategy, and Elizabeth from the USPTO, she talked a lot about business strategy with this. I eventually want to license that to everybody from agencies, other businesses, because when I came up with it, I'm like, oh, this is dope. So by me being able to use those symbols, because it is fully registered, so I can use my R with the circle, that shows a level of credibility, innovation in my business that shows, hey, I'm not just making stuff up. So again, when you put in the work to come up with these inventions, these symbols, they are designed to put a little bit of weight behind what you're doing. Just like if you put Esquire behind your name if you're an attorney, or you get to use doctor if you have your PhD, or MD if you are a medical doctor, right? Like letters matter, symbols matter with credibility, visibility, and innovation. So use them, because all of that stuff that helps your business too. People know you in this thing and you doing it for real. So just wanted to toss that out there. All right, I think we got time for maybe one question, and I'm going to actually ask this one of everyone. Let's see. What are the options for businesses if they find someone infringing on their intellectual property? So this could be a patent, a trademark, a copyright, trade secret. Like, what can people do in response? So for this one, I'm going to start with Sabrina, and then I'm going to go to Judy, Joanna, Xavier, and then finish with Stephen.
Yes. So I think what's important when you first think somebody's infringing is you need to do your research and make sure that they're actually infringing, because when you're registering trademarks, you're registering with respect to certain goods and services that are in your application, right? So if somebody may be using your name for something completely different, or on the other side of the world may not even be doing business in the US, has no intention of doing, it just depends. So you need to just be making sure that you're researching to make sure that what you think is infringement is actually infringement, because once you take that step, it can be really costly. And so just be clear about that. That may require you to kind of retain counsel. They can do that research on your behalf. The next thing I would recommend, because it's just a cost saving thing, instead of diving straight into something litigation or going to the TTAB to kind of either, if there's an application ongoing to oppose or to try to cancel something post registration, is you can send a cease and desist letter. That's usually a nice first start. Hey, I think you're infringing this. Here's the evidence. You need to stop, or we're going to pursue whatever the case may be. So you can start with kind of doing a cease and desist letter, kind of see where that pans out. But then obviously there's other considerations at play. Like, for example, if there's other applications pending and there's an opposition period, you may want to go ahead and try to oppose it before it gets registered, if you can afford that. If you notice something that's already been registered, maybe they're not using it anymore and you're able to prove that and you want to use it, or you've been using it and you know that they haven't been using it, you need to go ahead and get that canceled so you can register yours. It's very fact specific. And it kind of depends on where you are in the process. But the basis is just making sure that the infringement that you think is infringement is actually what that is. So yeah, that's kind of what I would recommend.
Yeah, in addition to what was mentioned, I would say something to consider is that nowadays on a lot of the platforms that you may encounter infringement, for example, YouTube, Instagram, Facebook, Amazon, when you saw something that's infringing, you can check the platform's intellectual property policy. Sometimes a lot of them have trademark policy. Amazon has this thing called brand registry, where a registered trademark owner can register their trademark, and that Amazon wouldn't allow people to use your name when you have proven that you have a registered trademark. So there are those mechanisms that businesses can and creators can use to protect their trademark as well, in addition to the traditional route, kind of like the litigation, TTAB, and sending them letters. Yeah, I forgot who's next. That's all I
I
have.
think it was Joanna. It was either Joanna or no, it was Joanna. Yes, it was. Sorry, I forgot the order too.
No, no worries. Building on what Judy just said too. There's normally social media platforms. It takes a little digging in navigating the page, but if it's not in the terms of service, sometimes the terms of service will have the link to the IP policy, or sometimes there will be like a little tab where it says like report infringement, or it'll say something. There will be an abbreviation for the DMCA, so the Digital Millennium Copyright Act. It's more of a copyright, right? It's more copyright than trademark. But what I have found is sometimes is that I've had clients that have encountered trademark infringement on these social media platforms, and so what I've done before is I've actually clicked on the DMCA, filled out the form, and then submit the PDF of the trademark registration with the PDFs of the screenshots showing the infringement, and that gets taken down within 48 hours normally. It has to be. It has to be, because there's Facebook and Amazon and YouTube, something that they leverage a lot to try to shield themselves from liability is saying, well, we're just an internet service provider, we're just an intermediary. However, if you present proof of registration, that goes away. That barrier goes away, because now they're on notice that you own this registration and that there's infringement happening on their platform, which means they have the obligation to take that down.
Thank you for that. I did not know that. Again,
Yeah.
it's things that are swirling where I'm like, let me pay attention. Thank you so much for that. And quick follow-up for the folks who have answered so far. I know you have to have an attorney on record when you file. So when you're responding to infringement issues, are you required to use that same attorney, or can you or should you secure a different legal partner?
So you are not required to use the same attorney of record. You could use whoever you want. So there are distinguished between people who practice trademarks before the USPTO and litigators. Because a lot of times people practice before the USPTO doing trademark registration may not be litigators. So often that will be handed over to a person who practices litigation specifically, because there are certain things and techniques they use on how to leverage the aspects of litigation. Maybe something in the record they identify that could be used for a strategy for settling, or it may identify there's issues in the registration issues in the let's say I mark this register that can actually go to cancellation. So there's many different things that can be done.
Thank you so much for that. And Xavier, actually, it was your turn to answer the question in general. So I didn't know if you had anything else that you wanted to add about infringement.
I actually will add something. So research is key. Research is vital. So everybody has spoken about the trademark side. I agree 100%. On the patent side, you are going to have to look. So if you have an issue patent, you're going to have to look through your claims to make sure that your claims can withstand a challenge. Because a lot of times, if you try to challenge and enforce infringement, the other person going to counter sue and say like, hey, your patent is invalid for, let's say, enablement, or it may be invalid because improper inventorship. So you want to make sure, or the claims might be broad. So you want to make sure that you've done your proper research and due diligence before you go ahead and try to enforce your rights, because people can counsel you.
Thank you. And Steve, you can close us out. We like almost right at time. This is perfect.
Great. So I'll say this. Clearly, litigation, any contested proceeding is very expensive. So I've always looked at it from the perspective of how can we negotiate this? How can we settle this? How can we mediate it in advance of trying to get to the process of going through and having a judge, somebody who really doesn't understand what the businesses even are, to make decisions, right? So I think that's probably one of the key takeaways from my perspective of how you can, manage contested in infringement activities, right? When it comes to the process, yes, certainly you've got to provide notice in a cease and desist letter. But I think there are also administrative remedies as have been discussed, including things like the trademark office is one that we've talked about, and obviously the proceedings there are much more compact and less expensive. But then you also can use things like UDRP for domain names, right? That's typical when you see somebody who's out there either usurping a domain name. Let's say you have the .com, but they're getting the .org and all the others associated with it, right? So you can those are proceedings that I have been very successful with in being able to literally stop those types of activities overseas, even. And the reason for it is because typically those entities that are out there gathering those kinds of secondary URLs are out there for purposes of just doing that, just getting them, and not even having a business that will respond to some of these things. So you need to consider that. But first and foremost, try to understand you do your research, but understand when you walk into this, even though you have what you feel is a very strong claim, it's always better to meet in the middle somewhere from a cost perspective, as well as from a perspective of how long is this going to take it and what is going to cost my business overall, because it's not just money, it's time and it's effort.
And thank you for that point about attention, because while you're dealing with all of this, even when you have legal counsel, you got a business to run, right? You have a career to manage, you're doing other things. And so you're absolutely right. I want to follow up on what Stephen said, just as a closing note. And this is kind of to sum up all of what we've discussed today. The key is to be thoughtful in advance about the defensibility of your intellectual property. Also be clear on the full process. That comprehensive search is important, because that'll even give you a clue as to potential for infringement. So if somebody's mark is really, really close and you're still able to get yours through and become fully registered, just know those people might not go away quietly, right? Or they might have an issue, or it might give you some hints of what is to come. And so again, that preparation, that knowledge, that visibility is key. But also keep in mind, and Elizabeth and Tamika spoke on this from the USPTO, protect your stuff comprehensively. So, like Stephen just said, don't just get .com, right? Or to the point that Stephen just made, don't just get .com, get .net, .org, .ai, .me. A lot of times domains are like $5, $8, $12. It's worth the $100 to use to just grab it. The other point is, create a landing page for what you're building. Even if it's a simple thing to say, hey, launching, like let's say now it's January 2025, launching September 2025, something where SEO will start to pick up this name, this thing, right? And it'll point back to you. So again, the whole key here is to have that visibility, plan in advance, have the right partners, be responsive, and be honest with yourself about the time, the resources, and the attention that is needed to fully protect your intellectual property, whether that is locally and nationally in the United States or internationally, because it's a whole different ball game. Thank you so much to the panelists, not just the panelists who are here today, though you all have been amazing, but also to all of the panelists that have been on even in the other sessions. I am so grateful for you all and so appreciative of you donating your time to this. Just FYI, these folks came here for free, y'all. Thank you so much. And I'm so grateful for their expertise, because this really is a labor of love. As you all know, it is not cheap to become an attorney. It is not cheap in time or resources to become skilled at what you do. And this is taken away from their billable hours to be able to give this information to us. And I'm so grateful and thankful. And I hope that you all have found value in giving your time. And I hope to the audience you all have found value in being able to receive this information. I'm going to be sure to post links on how you can reach out to these amazing folks. And I'm looking forward to future webinar series. Be sure to check Forward Collective Group's Eventbrite page and subscribe and follow us there so you can find out about the upcoming webinar series. We actually have one coming up in 2 weeks that is about economic considerations for small businesses. And you will not want to miss that one because I have some super dope experts who are coming on to talk to us. So I will catch you all soon. Please continue to be safe with the weather related challenges that are happening. And again, because it's still January, Happy New Year, y'all. Let's make 2025 extra strong. I'll catch y'all in the next one. Bye.
Thanks, Ken. Bye now.
Thank you.
Okay, thank y'all so much. I appreciate y'all. Oh my goodness, this was amazing as always. So I know for some of you, you've been on multiple sessions, and so I have the capacity to get a whole bunch of clips with just you talking. I would say we'll probably get on like a meeting together, and I can show them to you because I don't know if I can link them like publicly to y'all from Riverside. Riverside is weird on their blocks with that and privacy. But if you want that, like to